kick off the lunchtime and immediately following lunchtime panel. The format for this is slightly different than the panels we've had so far, because we have basically 3 speakers, but the way we've organised it is we have a lunchtime keynote to be followed by 2 panel speakers, all talking about internet domain name governance, internet domain name disputes. Alice is photographing me and I'm holding a bottle of water. That looks really professional. So I'm really, really thrilled as our lunchtime keynote to be able to introduce my colleague from really just 45 minutes down the road, Jeffrey Samuels, who's a professor. He's the David L. Brennan Professor of Law at the Akron Law School, and he's the director of Akron's Centre for Intellectual Property Law and Technology. And I've been really thrilled in the last year or so that we've actually had a much closer relationship with Akron and with their IP centre, and we've been able to do more things with them. So it's in that vein that I'm really happy that Jeffrey could be here today. He's an expert in trademark and unfair competition law, international intellectual property law. His past travels have actually taken him into service as the Assistant Commissioner of Patents and Trademarks of the US PTO from November 1987 to January 1993. He's been an adjunct faculty member at George Washington and George Mason law schools in DC, and he said that the most important thing to tell you is that he's a UDRP arbitrator, and he has actually presided over more than 200 disputes, so he's very, very familiar with the UDRP. So I'm going to turn it over to Jeff. Thank you.
Thank you, Jackie. Well, while you finish up lunch, I'm going to focus my remarks on some of the issues that I have confronted as a UDRP panelist. I will emphasize the term panelists because, as I will refer to later, this is not arbitration proceedings, so we're not arbitrators, and we're certainly not compensated at the rate of arbitrators. It's a mandatory administrative proceeding is what the ICANN UDRP is. So I'm going to be talking about some of the issues I've experienced and come across as a panel member, and some of my experiences in that regard. First, the timing of this conference is very appropriate because on December 1 of 2009, that'll be the 10th anniversary of the implementation of the UDRP. Let's go back to 10 years ago, actually a little bit more. And why was the UDRP created? Well, primarily it was to confront the problem of cyber squatting and to provide a vehicle for trademark owners to combat cyber squatting and to have abusive domain names transferred or canceled. Today there are about 190 million. Just think about that, 190 million domain names that have been registered. Another reason why the UDRP was created was because of the inadequacy of the then existing remedies. For example, the U.S. Federal Trademark Dilution Statute. While it had been used and used somewhat successfully by trademark owners in an attempt to combat cyber squatting, it was, I think most people recognize, a poor fit. And the other dispute resolution policies, including Network Solutions dispute policy, did not provide for the transfer of domain names. So there was a perceived need for a quick and relatively inexpensive way to address the cases of abusive domain name registrations. The average cost of a UDRP is about $5,000, far less than most cases that would be brought in federal district court. But the UDRP, of course, is not for every dispute. The hallmark of the UDRP proceedings are abusive registrations, bad faith, intent, where there is a legitimate dispute. That's probably not one that the UDRP is well equipped to handle. And where credibility issues are involved, that also is probably a situation where the UDRP is ill equipped to resolve the matter. WIPO, which is one of the two major providers of the UDRP, just announced the issuance of its 16,000th decision. And if you include the decisions that have been issued under the auspices of other providers, we're probably talking about in excess of 25,000 UDRP cases that have been issued since 1999. Over 40% of the cases originate in the United States, and over 75% of the cases, not surprisingly, involve the .com top-level domain. In addition, perhaps also not surprisingly, about 75% of the cases are default cases, that is, cases in which the respondent, the domain name registrant, does not file a response. Now, we know from some of the speakers this morning that in order to prevail in a UDRP proceeding, the trademark owner must establish that the domain name is identical or confusingly similar to a mark in which it has rights. The complainant, the respondent, must not have rights or legitimate interests in the domain name, and there must be evidence of bad faith registration and use. And the UDRP provides for a non-explicit list of circumstances that may support a finding of rights or legitimate interests, or support a finding of bad faith registration and use. Now, as a result of the need to establish all of the above elements of the claim, the UDRP does not reach all instances of cybersquatting. For example, I recently was involved as the panelist in a case that was brought by a famous athlete. The situation involved the registration of, as a domain name of that athlete's newborn son. The athlete's name was certainly is certainly a protectable mark. However, the mark in issue was not, at least in my opinion, confusingly similar to the domain name in issue. And while the son's name was certainly identical to that of the domain name, the son, since he was all of maybe 2 weeks old, did not have protectable rights in the mark. So, if you think about this, this is a situation that if you represent a celebrity and the celebrity is expecting a child, you probably would be wise to counsel the celebrity to register the child's name as a domain name at the same time, if not before, the birth certificate issues. Indeed, the respondent in the case indicated that it had so advised the athlete. Now, around the same time that the UDRP went into effect, the United States Congress, of course, got into action by enactment of the Anti-Cybersquatting Consumer Protection Act. This actually went into effect just a few days before the December 1 implementation of the UDRP. I'm not sure whether that was a coincidence or not, but in any case, we now have, if you are a trademark owner, a number of different options that you can consider if you're dealing with a cyber squat. Obviously, the UDRP and now the ACPA. ACPA provides for a civil cause of action against one who has a bad faith intent to profit from the mark, and the law identifies a number of factors relevant to the issue of bad faith intent to profit, many of which dovetail with the factors relevant in a UDRP proceeding, such as whether the defendant is making a bona fide non-commercial or fair use of the mark, and whether the defendant has offered to sell the name to the trademark owner or any third party. Unlike a UDRP proceeding, in an ACPA case, if you prevail, you can get damages, including statutory damages, as one of the few areas of trademark law which statutory damages are available of no less than $1,000 or more than $100,000 per domain name. And of course, the ACPA also provides for in rem jurisdiction where personal jurisdiction over the defendant is not available. Now, as Jackie mentioned, I've been a panelist since really the beginning of the UDRP, and have probably decided either as the sole panelist or as a member of a three-member panel about 200 cases. Now, the UDRP is hardly a model of clarity, which is probably one of the many reasons that it's difficult to reconcile some of the cases. And of course, all of the cases are very fact-dependent. For that reason, I recommend that if your case presents some unusual set of facts, you probably would be wise to request a three-member panel. It's my experience that three-member panels often result in more considered decisions. We do discuss each other's views and we take them into consideration. Sometimes we change our initial view of the case after having an opportunity to hear the views of the other panelists. But certainly, you avoid the situation where you're going to get a panelist whose views on a particular issue are in the distinct minority of the views of all the panelists. Also remember that a UDRP is, as I indicated earlier, it's not an arbitration. And thus, U.S. courts give no deference to UDRP decisions. And of course, the procedures provide that if a respondent domain name registrant loses in the UDRP proceeding, it does have an avenue of appeal through the filing of a civil action under the ACPA. Now, how do I go about deciding these cases? Obviously, you read the pleadings, if you will. It's usually there's a complaint, and if there is no default, there is a response. In many instances, there are additional submissions by one or both parties. There's usually, at least in many cases, there are rather voluminous exhibits that are submitted as part of the submission as well. But my philosophy, I guess one that my mother instilled in me, is probably the less said, the better. And that's why my decisions tend to run probably on the short side, maybe 4 to 6 pages. There are some panelists who like to go on. There are some panelists who like to get their decisions published, but I'm not one of them. I mean, my philosophy is get the case decided in the way that you believe it should be decided, make the necessary findings, and then move on. These cases, my decisions, any panelist's decisions, is not presidential. And there is no appellate body either. So I try to decide the case within the 14-day period that is provided. Sometimes that's difficult to do if there are additional submissions. Sometimes, in many cases, if you have a three-member panel, particularly if one's in the United States and one's in Europe and one's in Asia, and seem to be more and more of those types of cases, it's extremely difficult to get that case decided in 14 days. Even though we communicate via email, everyone's schedule is different. And sometimes it's difficult to get everybody's views within the time necessary so you can get the decision issued within that 14-day period, but you can always get more time. All right, now what are some of the issues that I've confronted? Other panelists, I'm sure, have confronted these same issues. What about the issue of establishing rights? In most cases, the trademark owner establishes rights through presenting evidence that it owns a U.S. registration or a registration somewhere around the world. That's the way rights under the policy are typically established. But what happens if different offices have different views on the issue of registrability? In the early days of the UDRP, I was involved in a 3-member panel decision involving the mark beanies, the e-beanies. And while there was some U.S. registrations issued for some of the marks in issue in this case, there was at least one mark that there was no U.S. registration issued. There was an application, and I guess there was an initial refusal to register. The trademark owner, though, was able to obtain a registration from essentially a deposit country. And the issue arose as to whether it could be found under those facts that the complainant had rights in the mark. One of the panelists, the dissenting panelists, took the view that we wanted to discourage what he called forum shopping. That is, allowing a trademark owner who maybe could not obtain a registration in jurisdiction A to then run off to jurisdiction B and get a registration and rely on that registration to establish rights. The majority, including myself, took a different view with respect to what type of registration would be sufficient to establish rights under the mark. Our view is a registration anywhere in the world would be sufficient. After all, the internet is an international means of communication. What about if you do not have a registration? Can you rely on common law rights? Most panelists, including myself, will say yes, but there you really, if you're the trademark owner, putative trademark owner, you really have to set forth a lot of evidence to establish, how long you've used your mark, the amount of advertising, promotion, sales, all the things that one would normally establish or attempt to establish before a court of law to make out a case of common law rights. And what about these so-called sucks cases? You've all heard about them. Is there any confusing similarity when somebody registers a domain name? Today, about 26% of the Fortune 500 companies have registered a domain name that consists of and you insert the company name, sucks.com, these so-called defensive registrations. Is there any confusing similarity? Well, my view is, but I think at least I'm told it's the minority, is that there is no confusing similarity. One case that I was involved in involved airfrancesucks.com. Obviously, somebody had a bad experience flying on Air France. And it was a 3-member panel, and I think I was the only one from the United States. There was one panelist from France and another one from some other country in Europe. And I took the view there was no confusing similarity, but perhaps understandably they took a different view. But there is definitely a split of opinion with respect to these sucks types cases. So if you're representing a party involving a domain name that involves a sucks domain name, you probably want to do some research with respect to your panelist, depending on which way you might want it to come out. What about the issue of whether or not confusing similarity, the issue of whether a domain name is confusingly similar to that of a mark in which the complainant has rights? Does that trigger application of the so-called Polaroid likelihood of confusion factors? Particularly at the early stages of the UDRP, there were many panelists, if not most, who took the position that in order to establish this issue of confusing similarity, it was incumbent upon the trademark owner to go through the whole litany of 8 or 10 or however many Polaroid factors there are. I think that the view on that issue has changed gradually over the years, so that today you don't see that being argued, or at least very rarely, by trademark owners. And the view is, in making the determination as to whether there is confusing similarity between the mark in issue and the domain name, you really just look at it from the perspective of how do they look, how do they sound, rather than going into the whole likelihood of confusion Polaroid factors. Paragraph 4B, 4 of the policy talks about intentionally attempting to attract for commercial gain internet users to one's website. Well, what happens if the domain name registrant, as it frequently does, claims that it did not know of the complainant's mark? Lots of issues are presented under this scenario. Can the complainant rely, assuming it has a U.S. registration, on the constructive use concept to establish the requisite intent? In my view, the answer is no. Some panelists, though, take the opposite view. But constructive notice really doesn't go, in my view, to the question of bad faith intent to register in use. What about where the respondent presents a plausible argument for the use of its domain name? For example, I just decided a case where, well, it's sort of an analogous situation. If, for example, there was a gentleman named George Edwards who registers georgeedwards.com as a domain name, and then later registers ge.com as a domain name, and he argues as justification for doing that, well, it's just an abbreviation for my earlier registered domain name, and therefore I didn't have any bad faith intent to register and use the domain name. You get into lots of credibility determinations, and you have to sort of weigh, at least I weigh, the plausibility of the justification against really the strength of the mark. If the respondent submits a signed declaration or affidavit, I'm probably going to give that more weight than if they just make argument. Although I'm not naive enough to, I understand that people, even if they sign a declaration, they sometimes, everything in there is not necessarily completely truthful. Nevertheless, I do give that more weight than if somebody is just making argument and just saying that I did not know of the plaintiff's mark. So you got to weigh that against the strength of the mark. So that's why it's always important for the trademark owner to put something into the record with respect to the strength of the mark, even if it has a registration. So again, sales, advertising, anything that goes to the question of strength. Also, you may have to consider the geographic proximity of the parties. If the respondent is in Mongolia and the trademark owner operates only in the United States, well, then maybe it's less likely that the respondent acted with the requisite bad faith intent. What about offers to sell the domain name? I believe one of the speakers this morning talked about that. Well, if the respondent offers to sell the domain name to the trademark owner, that is usually really good evidence of bad faith registration and use, all things otherwise being equal. However, frequently what happens is that the trademark owner takes the initial step and says to the domain name registrant, how much do you want for the domain name? And the domain name owner will name its price. Well, in that case, can you say that under one of the factors that can lead to bad faith registration or use, that there has been an offer to sell it to the trademark owner or to a third party for more than the costs of obtaining the registration? Probably not. But again, these are all highly factually dependent determinations. I guess in sum, the best a panel member can do, given the fact that we don't have the opportunity to see the parties testifying under oath in a court of law, is to exercise our best judgment. And certainly, I think it's probably safe to say the more cases that you handle, probably the better judgment that you have, and you've seen it all, so to speak. Although, again, the amount of the ingenuity sometimes that are the arguments that are presented by the respondents sometimes are fairly impressive. And there are some lawyers who have made their living in representing these respondents, and I can always tell when I see who is submitting the response. I always know if it comes from this lawyer or that lawyer that I'm probably going to have to look at it a lot more carefully than might otherwise be the situation. Now, WIPO has prepared and has available on their website an overview of some of these issues and some of the other issues as well. And I understand that they have a new version of their overview that will be coming out shortly. Also available on the WIPO website is a means to electronically search ICANN decisions issued by WIPO panels based on the issues, the parties, and so on and so forth. So if you get involved in one of these disputes, I would recommend that you go to the WIPO website and do some research. Now, what's going on with respect to some new initiatives relating to the UDRP and to domain names? Now, today there are 21 generic top-level domains and around 250 two-letter country code top-level domains. In June of 2008, ICANN's board of directors approved the introduction of an unlimited number of new generic top-level domains. According to ICANN, the proposal, which it hopes to implement next year, would promote innovation and competition. However, as you might imagine, the trademark owners are not happy, and that's probably an understatement. They see the potential for more cyber squatting and the need to spend more money policing the net. In an effort to address the concerns of trademark owners, ICANN will require all applicants for one of these new generic top-level domains to describe in their applications the rights protection mechanism that they propose for second-level registrations. And all new generic top-level domains must ensure that the second-level registrations are subject to the UDRP. In addition, ICANN is considering proposing implementation of what it refers to as a uniform rapid suspension system. And I understand some of the panelists that will follow me will be talking a little bit more about this. This uniform rapid suspension system will be for so-called slam dunk cases, where the evidence is clear and convincing that one is engaging in cyber squatting. However, as currently envisioned, this process can only result in a suspension, not in the transfer of the domain name. And moreover, any of the registries would not even be required to adopt the procedure. So trademark owners are still not very happy. And on September 23rd, a hearing was held before the House Judiciary Subcommittee on Courts and Competition Policy on this new proposal by ICANN for introduction of an unlimited number of new generic top-level domains. The president of the International Trademark Association testified that, quote, abuses of the domain name system remain at extremely high levels, due in part to ICANN's ineffective management of the Internet's naming and addressing system. INTA believes that an introduction of new generic top-level domains may offer benefits to consumers only if the new generic top-level domains are introduced in a justified, timely, and responsible manner based on an empirical understanding of the realities of the domain name marketplace, which probably is a long way of saying don't do it. Otherwise, INTA believes that unproductive and harmful uses of the domain name space will outweigh any potential benefits that may flow to the public. So I guess the question is whether this gap between ICANN and its proposal and trademark owners, whether it can be bridged. And frankly, it's hard to see how, at least bridged completely. The parties have different interests to protect, and they have different perspectives. The trademark community is concerned with the protection of marks. ICANN's perspective is broader, focusing on making the internet more accessible and user-friendly to users around the world. Now, in addition to the proposed rapid suspension system that I just mentioned, WIPO has also proposed adopting what it calls a fast-track UDRP. As I noted earlier, there is about a 75% default rate in all decided cases under the UDRP. In addition, roughly 25% of all WIPO cases settle before the matter is even referred to a panel. The proposed fast-track system would lower filing costs, at least based on WIPO's estimate, by about 50%. But it would also impose a limitation on the number of words and the number and pages that could be submitted via exhibits. The matter would be decided by a single panel member. The 20-day response period in which respondents have an opportunity to file a response under the UDRP would be preserved, and a respondent could always request that the matter be resolved under the standard UDRP procedures. A fast-track decision would be no more than 2 to 3 pages in length, and the case would be decided in 2 to 3 days. WIPO has indicated that, much like the USPTO, they'll come up with various form paragraphs that a panelist can just plug into his or her decision for each of the various elements of the UDRP. So we'll see if that proposal, as well as the rapid suspension proposal, get implemented in the near future. There are, as you can see, a lot of new developments down the road. Hopefully, once implemented, they'll be for the better, but I guess we'll have to wait for the results. I think that's all I have prepared to say, but I am certainly willing to answer any questions about the UDRP procedure, any of the issues that come before UDRP panels, or anything else regarding the UDRP. Yes, Carl.
Yeah. I mean, we may differ on whether the UDRP is a good tool or not, but going back to the Glenn Beck case, where you had the Glenn Beck raping young girls, whatever, what about, would it be a good tool, would the UDRP be a good tool to be expanded to vindicate rights in names that are not trademark based? For example, if John Doe were to, he has a right in his own name, but he can't trademark it because he's not in commerce for it. But would he have would it be good, would it be useful to have the UDRP expanded so that John Doe could go after someone who is abusing John Doe registration against that person? My opinion is no. That the UDRP was designed to handle a specific factual situation where the complainant has trademark rights. If it does not have trademark rights,
then there are other avenues, perhaps, that John Doe can pursue, whether under state or federal law. And if not, then this is just not a situation that the law should provide relief.
Because I have a follow-up question.
Yeah.
Which was, the UDRP was designed to create the expedited process, and you're just saying that John Doe would have to use the non-expedited processes. If that argument is valid, then why should the intellectual property industry all get an expedited process? Why should they not also be required to fall back on the slow and expensive processes that the rest of us are required to use?
Well, I mean, it just really gets down to a policy judgment as to, what the UDRP is for. As I think I've indicated, it was not designed to handle all cases of abusive registrations. There are, I think, you have to impose certain limitations or certain requirements, just like you would impose requirements on a plaintiff in a civil lawsuit. So it just really gets down to a policy question as to how wide-ranging you want to have this UDRP. Jackie? Oh, no, somebody else? Yeah. Christine?
Do you see many disputes in which the claim is that the domain name is dilutive of the trademark? I'm not sure I've ever come across one of those. And if so, or have you experienced one of these, what do panelists use to decide that question?
Well, the answer to your first question is no, so I don't have to get to the second one. No, I mean, that would come up under the ACPA, where there is a provision there that if the domain name is dilutive, then that can give rise to a cause of action. I've never seen that raised in a other than maybe just in passing, the use of the term dilution, but not really seriously raised in a complaint under the UDRP. Yes?
Do you have any thoughts about if there's lessons we can learn from the ways in which we're seeing keyword disputes being handled in the search engines, and in particular, the search engines' voluntary policies to intervene with respect to certain trademark rights, of which the different search engines vary. But do you think there's any lessons that the UDRP might learn from how the search engines are coping with complaints about their trademarks being used as keywords?
I haven't given that any thought. Could you elaborate just a little bit more on that question, and maybe something will enter my mind?
Well, there's two different angles that we could approach it. One is obviously that so much of the action has moved from people putting in domain names into address bars and instead doing searches in the search engine. So the search engine policies in some cases have more impact than the UDRP.
Right.
And in the other perspective is simply that both of them are trying to deal with what is effectively the same problem, that a trademark has been used as a way of attaching content to it, and then usually, in many cases, being used to create commercial value for the person who's making that association.
Yeah, I think the answer to your question is I don't think that anything in the UDRP would be particularly relevant to that, because the UDRP, I mean, from my perspective, the focus is on bad faith intent. In resolving these cases, assuming that the trademark owner can establish rights and confusing similarity. Whereas, and I think Professor Dinwiddie made this point, with respect to the search engine keyword cases, really the focus seems to be more on effect. So I'm not sure that anything in that's been decided under the UDRP would be, at least my initial view, would be particularly helpful.
I have the microphone now. I can ask my question. I actually have a follow-up to Carl's question about personal names, which I've written a lot about and have been kind of obsessed with, as my students know. But my follow-up is, I agree with you that the UDRP is not designed to protect personal names, and it's not just the fact that it doesn't say personal names as something to be protected. The whole language of the UDRP is based on trademark concepts. My concern about there not being some UDRP-like equivalent for personal names is that My impression is that UDRP arbitrators, I don't know if you do, but a lot of them increasingly do very quickly find unregistered trademark rights in all manner of personal names, even ones that you wouldn't think would really be a trademark.
Yeah.
And there seems to be a lot of arbitrariness about the standards they use to work out whether there's... So what would your comments be on that issue?
Yeah. I mean, there actually is a fair amount of panel decisions on that point. If the evidence establishes that the name is being used for the purposes of a trademark, it's being used in connection with the providing of a service. I mean, there are lots of names that are registered as trademarks at the USPTO when they're used on goods or in connection with services. And if that's what the evidence shows, then I'm going to find that there's a protectable interest. If somebody's just trying, an average citizen who's not involved in a business and not providing services over and above one's normal business, but not really selling it to the public, so to speak, or, the celebrity entertainer, athlete type situation, it becomes much more difficult in that situation to establish rights protectable under the UDRP. So it really gets down, at least in my view, again, to whether they are providing, goods or services, to the public over and above their day-to-day, work.
Excuse me. So I'm not sure that this is a question exactly, but I hope I'll see if I can find one at the end of recounting a couple of anecdotes. So I'm a UDRP panelist for WIPO as well, or at least I think I am, because I haven't decided a case for them for about 4 years, and I think I started with them about 2000 maybe, and in reflecting back on why I'm no longer a panelist with them, or at least I am in name, but they don't give me any cases anymore. There are a couple of kind of incidents which I actually have to say gives me cause to be kind of glad that they don't send me any anymore. Mm-hmm. One of the things that you haven't touched on, I guess this is the question, is the nature of choosing the panelists in order to determine the cases. This is something which has been it's been talked about previously, but I have just two anecdotes to kind of use as examples and ask you perhaps to respond to it. So one was that I was a panelist on a 3-person panel in relation to a registration that happened in South Korea, where the decision, or the complaint response and decision was all in Korean, which I'm not fluent in. Let's put it that way. I can recognize that it is in the Korean script, but have no idea how to do it. And I was the chair of that panel because WIPO AMC was concerned about the Korean panelists who were on that, and the reason for that was that the process by which potentially abusive registrants were able to game the system a little bit, at least in their view, was that they would register with a South Korean registrar, which meant that it was permissible for them to insist that the language of the proceeding be in the language of the registrar, which meant that they got all South Korean panelists who, in the eyes of WIPO, were very much skewed towards South Korean respondents, and that they were unhappy with the way in which the decisions were coming out, so they had to find somebody to basically show them the whip and ensure that they didn't decide the wrong way. It was like literally the wrong way.
Right.
So they provided me with the translations of this material and so on, and I actually got my own separate translations of all the material, so I could determine whether or not, in fact, that those translations were accurate, which they were. And so, I ended up concluding I wanted to transfer the domain name. It wasn't as though that there was any problem there. But so that was an unusual kind of result. That in fact the AMC at WIPO were very clear about trying to skew the outcome of that particular decision by appointing me. as a panelist. The reason that I no longer seem to be sent cases from them is because one complainant complained about a particular domain name. It was registered dvla.com. And the complainant was the Driver Vehicle Licensing Agency of the UK government. They're essentially the DMV over there. And the complaint that was the complainant. The respondent didn't respond. Probably didn't get it or didn't do anything about it. But DVLA.com happened to be the Delaware Valley Lighting Authority, as I recall, a lighting agency or something like that. It was a group it was a company that clearly had the rights to do it. And I concluded, sua sponte, that this was an example of reverse domain name hijacking, which was, I think, the first time ever that had been decided. And it certainly wasn't something that WIPO was happy with. In fact, they pushed back 5 times on my draft decision, saying, we don't think that you should decide that. And I said, well, no, I think I should decide that. And then they said, well, we don't think you can decide that. And I said, well, I've checked the rules, and I think I can. And in fact, I think I'm going to. And did, and it caused a very, very minor flurry in private eye in England and so on. And since then, oddly enough, I've not received any requests from WIPO to decide cases. I don't know that there's a question at the end of that, except perhaps, do you have any response to the way in which private actors can influence the outcome of these decisions?
Well, I mean, if the question is how does WIPO select the members of the panel, I have no idea. I understand there are probably in excess of 300 names on the WIPO panel. Can you
remind them of me?
Well, right. Yeah,
Oh, it's Brennan. Oh, I have an art collection.
Yeah, right. I mean, right. You know, there are certain situations where they may be looking for somebody from a country in order to balance out the geographical representation of the panel. I think I might have been involved maybe in a couple of cases where that was the case, but that's certainly not most of the situations. So I always just assume that they based on the number of cases, they just sort of go through their list and assign the cases to some extent arbitrarily.
My grandmother used to call me a nudnik because I seek out trouble and exacerbate it. There are other top-level domains. I have my own top-level domain, created as a joke, but it's real, .ewe. How it came there is a whole long story. I refuse to saddle my customers with a UDRP requirement. Now, it's a real operational top-level domain. It just doesn't happen to be in ICANN's root. Mm-hmm. What I'm suggesting to you is, and I will be getting this in my talk later, there's a real possibility of top-level domains coming out that refuse to follow ICANN's rules. And this is also already occurring in the CCTLD space, which is, as you mentioned earlier, the dominant portion of the top-level domains that exist.
Okay, well then if the UDRP is not going to be provided for by these new registries, I mean, I think under the ICANN proposal, they have to have some dispute resolution policy in effect. Right, and what that will be, I don't know. I mean, it seems to me that the UDRP, for all of its problems, has been pretty effective given the number of cases it has resolved in a relatively inexpensive manner. Not to say, of course, that it cannot be improved, and maybe having different systems in place will lead to improvements. So I guess what I'm saying, maybe it's not all so bad if they don't have the UDRP, if they have some other means to resolve these disputes, and let's see if that way is better.
Hi, just quickly, I wanted to know if you could comment on the statement from the lady from the EFF that a weakness in the UDRP is that American law does not apply. And given that the participants, the parties involved are often coming from different jurisdictions, the extent to which the panelists use general conflict of law principles in deciding to rely on the law from any particular jurisdiction.
Well, I think most of the cases, at least at the early years of the UDRP, did involve two U.S. companies, so that issue didn't really come up that much. And the reality is today it doesn't come up that much either. Over the 10 years and 25,000 decisions, there has sort of been a jurisprudence built up. So while I won't say that U.S. law is applicable, because there's nothing, U.S. law as a whole is not applicable, but lots of the principles that are found in U.S. law are applied in these UDRP cases. Now, if you have a U.S. trademark owner who's based in the U.S. and a domain name registrant who is in France, the only issue that would perhaps present the conflict would be on the issue of rights. And since probably in 95% of the cases, the trademark owner, the party in the position of the complainant, has a registration, it really doesn't really present a problem. I guess the only time it really would present an issue would be if there was no registration, and then you'd have to perhaps look into whether the country of the domain name registrant recognizes, common law rights, or whether it requires a registration. And if it does require registration, then the panelists will have to, make a determination as to whose law applies. And the answer is probably going to be they're going to look at what the body of the UDRP jurisprudence provides for, what the prevailing view is.
If there's no more questions, what we might do is personally thank Jeff for that.
Thank you. Appreciate it.